Uh, Today, we seek a reversal of an adverse pension decision. In the pension fund's decision related to benefits to Mr. Haley, they awarded a not in the line of duty disability benefit pursuant to 40 ILCS 5/4-111. And we are seeking benefits pursuant to 40 ILCS 5/4-110. And it's our opinion, based on the manifest weight of the record, that the court should overturn the pension fund's decision. Uh, Both parties have briefed the standard of review. Both agree that it's a manifest weight evidence case and that the court should adopt such in reviewing this matter. So the issue is on January 2nd of 2016 was a call that Daniel Haley responded on and participated in, a causative factor in his psychological disability. So January 26, 2016, Daniel Haley and his partner respond to a call, report of a woman having a baby. They arrive on the scene. They find a patient standing naked in the shower. And while she is standing there, there is a partially delivered baby in the birth canal, and she is trying to deliver that baby. It was apparent to Haley that there was no blood flow, that this was a significantly distressful incident. At one point in rendering care and treatment, he inserted a couple of fingers in the birth canal in an effort to create a passageway for air to be able to.
Although you focus on that incident, Mr. Haley himself didn't, when previously talking to mental health professionals on a number of occasions. Isn't that true?
Yes, Your Honor, it is true.
And he was already diagnosed with PTSD, was he not?
So I don't think there's any medical evidence that reflects that he was pre-diagnosed by a medical professional prior to it, but he certainly had stated under his own impression that he had suffered from it.
And that's why he saw Dr. Gura.
So he started treating with Dr. Gura. That was the first treater that he went with, and that happened not soon after the incident. And then he had switched to another provider after that. And then there was a court-appointed provider as well that he had treated with as a result of the divorce proceedings that undertook after the incident. So as part of all of this, ultimately the department ordered Mr. Haley to undergo a couple of fit for duty examinations. And those were with Dr. Campion. A couple of things to note in particular with Dr. Campion was first, he had administered a battery of tests on each occasion. This was done twice over the course of 2 years. And neither time did Dr. Campion ever assign a psychological diagnosis, what may be or may not be afflicting Mr. Haley. But Dr. Campion also never came and offered a causation opinion either. He only said that.
What were his directives?
Excuse me?
What were his directives?
Well, he didn't have a directive to issue a causation opinion.
Okay, well, that kind of takes care of why he doesn't give a causation, right?
Well, I agree, Your Honor. But the pension board relies on Dr. Campion's opinion that it was not related to the January 2016 incident. But Dr. Campion doesn't give an opinion either way. So if he doesn't say it is or it is not, then how can you rely on that opinion in support of the denial of the benefit?
Dr. Harris or Dr. Campion?
So I'm sorry, Your Honor, I talked over you.
Dr. Harris or Dr. Campion?
So right now we're talking about Dr. Campion. So Dr. Campion does not give that causation opinion. And neither does Dr. Harris in his reports either.
Because all he's doing is looking for fitness, correct?
Dr. Campion is strictly doing a fitness for duty exam. And I would agree that those are different than the exams that the pension fund ordered, where they asked, I think, 8 or 9 interrogatory questions for their physicians to answer. One of them was a causation answer. So as we look at Dr. Harris's opinion, Dr. Harris doesn't give a causation opinion either. Dr. Harris
Why
talks.
is disability is not service related a negative causation opinion?
Well, he does say that at the end, yes.
Well, that's kind of where they normally put it.
Well, there was a series of interrogatory questions. If you look at Dr. Wine's or Dr. Agarwal's opinions, they list
We're
those.
talking about Dr. Hare.
Yes, sir. But
It's not a comparative analysis as far as the format of their answering questions. It's the substance of what they say that's relevant.
yes, sir. Dr. Harris also fails to give any opinion as to why he is disabled. He doesn't say, other than saying it's a non-service related disability, he doesn't say why he's disabled. Is he disabled because of a psychological injury? Is he disabled because of his cancer? He doesn't give any reason why he's disabled, just that he's disabled. Also, if you look at the records
Well, from his report, we know that he knows about his Haley's mental health treatment, correct?
he references it generally, but unlike the other opinions, and the pension fund says that he had the most extensive and detailed report, but he never cites to the medical records. He never references any of them, and he's basically silent on that issue. So if he's the most detailed,
Did he say anything wrong?
Dr. Harris, I
Yeah.
think it's the lack of any opinion on why he's disabled at all, the lack of any reference to the medical treatment, the lack of any psychological diagnosis are all problematic and why his account should be set aside. It's resemblant of Wade, and in Wade v. North Chicago, where the doctor also ignored the medical records and didn't reference any of them. Whereas if we see Dr. Wine and Dr. Agarwal, they went through a pretty extensive review of those records and discussed the other issues that are with it. Now, we don't
In Wade, wasn't it the fact that the doctor's opinion either ignored or completely misunderstood objective medical records?
Yes, sir. And we think that parallels this with Dr. Harris.
Okay.
So as we go through and we look at those comparisons, we can see the difference in those perspectives of those doctors. And we think Harris should be set aside. Now, as we look at the timeline and how things affected Haley, there's no doubt that he had other psychological injuries in his life. The loss of his brother was a significant impact. There's no doubt about that.
Well, everybody agrees he's disabled, right?
Everybody agrees he's disabled. The issue was the January 2016 call at least a causative factor? Did it have some part of all of this? Or under the board's opinion, it had absolutely zero to do with anything and had no impact at all. That's really kind of where I think the line in the sand really kind of falls. So, but if we look at how this affects Haley, a couple of months before the incident, he is getting employment reviews from the department where they're telling him that he consistently displays pride in the department, positive attitude in his work. He's open and communicative and effectively works through conflicts. He's even being told he should take advanced firefighter and officer courses so that he can advance in his career. This is just October and November of 2015. We have the incident in January. And then just a few months after that, we see a real polar opposite effect where he is now sliding down and nobody's really recognizing what's going on here and what happened and how it's affecting him. And rather than looking at this in a wider light, they see this more as an employee problem who just doesn't like to get along with people. But that's a pretty short 6-month window. And if you look at those employment reports, for example, I'm on page 1511 of the record. We see where he's working hard and he's going good. And then just a couple of months later, his battalion chief is writing to him, telling him how bad he is doing in this employment and that he's really got to consider things in life. And that's on page 1503 of the record. So we see how this thing is really starting to affect him in life, and that is out there.
Changed. The evaluator changed, didn't it?
No, it was the same evaluator, I believe, Your Honor.
I thought it was OA first and then K.
I could be wrong. I know in my report that the battalion chief had written it. I don't know if that battalion chief had changed to a different person or not. So I don't want to misrepresent myself to Your Honor.
Well, 2015 was OA and the 2016 was K's.
Okay.
So K's came later.
I stand corrected. Thank you, Your Honor.
Good.
So we see this problem. Then he goes through the evaluations with Campion, and we see these reports coming out from Harris and Agarwal and Wine. And Agarwal and Wine find that it is absolutely related. The pension fund also puts, as I started to say earlier, an emphasis on relying on Campion's report. But again, Campion doesn't identify that he had any medical records related to him from the pension fund or from the city as part of his fit for duty. And again, it was a fit for duty, but he does find that he's not fit to work. The other thing that we find problematic that we'd like to point out for the court today is when we look at the testimony of two witnesses that the pension board called in this matter. The first one was Cassidy. And the goal of Cassidy's testimony from the pension board was to pin down this theory, and what the pension board is alleging is that the only reason that Haley applied for these disability benefits was because he was going to get fired and he was motivated by money in attempting to get disability benefits.
They have gotten that idea.
I'm sorry, Your Honor?
Where would they have gotten that idea?
Well, that's what they were getting through the testimony of Mr. I'm sorry, I turned the page here.
Haley. They got it from Haley.
Well, they were using Cassidy's testimony in an effort, allegedly, that that's who Haley had a conversation with. Except when we look at the transcript and we pin down what Cassidy was really testifying to, he couldn't tell us or testify to when that actually occurred and what period of time. And
well,
repeatedly,
that's true. That's true. He may not know chronologically when it occurred, but he said what your client said, correct?
well, and I think the timing is important, though. So if we were,
Well, okay, the answer to the question is either yes or no.
I'm sorry, Your Honor.
Did he relate what your client said as to what his intentions were if they were going to proceed?
So my answer, Your Honor, would be that was allegedly said. And if it was said, and based on the timing that Cassidy testified to, then that conversation occurred after Haley already filed his disability application. So there was no jeopardy of being fired. Once you file a disability application under the firefighter pension code, the employer cannot terminate you for the reasons for which you filed that application. So if it happened in the timeline that Cassidy said, and I do say if it happened, it really wasn't relevant because he had already filed his application when he said that, if he said it. I think the other thing that's supportive, I think Cassidy's testimony is problematic. I think the other thing, though, that's supportive is, and the pension board doesn't talk about it at all, is if you, in their decision, but if you read the testimony of Cavs, we can find how this call really affected Haley. So they're at the hospital, they bring the baby to the hospital, they find out that the baby had passed, and Cavs is looking around for Haley, and he finds him alone in a room, and Haley is crying. And when questioned about it, and if that was unusual to find Mr. Haley in a situation like that, Cavs says yes, that was really unusual. it's our opinion that the records and that the manifest weight of this result should overturn the pension fund's decision. And I thank the court for your time. If you have any other questions, I'm happy to answer them.
We see none. So thank you, counsel. Mr. Raja, on behalf of the appellee, you may make your argument at this time, sir.
Thank you, Justice. On behalf of the pension board, we feel this is a case where plaintiff is asking this court to reweigh the evidence and assign greater weight to other doctors and to the credibility of the applicant, where the pension board is charged with doing that function. When you look at the manifest weight of the evidence standard, the board has to point to competent evidence in the record to support its decision. And we certainly do that here. As pointed out by the justice, the board had a couple of reasons for denying the duty aspect of the claim. While they did find he was disabled and granted him a disability pension, it was the causation part that the board took issue with. And the basis for denying that this was work-related was based on a couple of things. One, they relied upon Dr. Harris. Now, appellee continually says we relied upon Dr. Campion, which the board did not do. What we said in our decision in order was that we relied upon Dr. Harris because he took a look at a more thorough look at the treating physician reports, where there was no mention of this January 2016 call, which he found significant. He based his opinion that this was not duty related on the treatment records, on his clinical evaluation, and it was consistent with the fitness for duty examinations of Dr. Campion, which was performed by the municipality. In that, he's seen Dr. Campion on two different occasions. One was in February of 2018, where Dr. Campion said that that he was unfit for duty because he complained of financial stress, that some stress dealing with a rental business, his marriage, the death of his brothers, and frustrations over disciplinary issues with the fire department. He never mentions in that first evaluation anything about a January 2016 call. And that after that first initial evaluation, the applicant files that's when he files his disability application. And in that initial application to the board, mentions nothing about PTSD or this call in January of 2016. He files for disability based on the fact that he has a compromised immune system. It's during this time period when this conversation takes place with Battalion Chief Cassidy. And we know that based on the substance of the conversation. He tells Battalion Chief Cassidy, if I lose my job, I'll just file for a disability pension for PTSD. So it's clear at that point he had not lost his job. So where the appellee says it had to be after he applied for disability, that just doesn't make sense, and it can't be true in the record, because he's still employed at that time, and he's saying if the department tries to let me go or find me unfit, then I'm going to apply for line of duty based on PTSD. And up until that point, even the second evaluation by Dr. Campion, which occurs in February of 2019, the record is devoid of any complaints by the applicant of this January 2016 call. He's evaluated by the initial psychologist in February of 2017, right after his wife files divorce papers. And that psychologist mentions a whole lot of psychological problems, but not one of them relates to the January 2016 call. She references schedule changes he complains about, shift issues that he's having, his brother's death, upset about nursing home calls, his wife trying to take the kids from him. But again, no mention of this January 2016 call. It's only when Dr. Campion finds him unfit that he then files a second disability application with the fund in February of 2019. And that's the first time, as the board sees it, making good on his promise to go ahead and seek a line of duty for PTSD if he's not allowed to come back to work. And that's when he does change his application after the second evaluation by the employer's physician saying he's unfit to return. So that's where
Counsel, can I ask a question?
Sure, Justice.
Cassidy, we do know from Cassidy's testimony, do we not, that it was he went to talk to Haley before the 1-year timeline was going to expire for him to return to work on administrative leave, correct?
That's what Battalion Chief Cassidy does reference. Yes, Judge.
Okay, so that would
He
be
did have trouble identifying the exact date and time, but he was
right.
trying to reference it for the board the best he could.
But from the record, we could tell that would be January or February of 2019. Right?
I believe so, yes, Judge, because it's still before that final evaluation by Dr. Campion, which was in February of 2019, that he's saying
Correct.
if they find me unfit, then I'm going to file for this line of duty for PTSD.
And then February 21st of 19 is when he files his application that includes the PTSD.
That is correct.
Okay.
And that's where the board took issue with the credibility of the applicant. It's his inconsistency in his application. It's the fact that he's had significant disciplinary issues, and his complaints with respect to the discipline is all about shift issues and issues with coworkers. And he had referenced that he's going to blow the place up. So there was an internal investigation about that. And at no point does he ever make the allegation that he's having any difficulties because of a particular call. And in fact, the board members who know, at least the active guys who were familiar with Haley, had I believe felt that he was one of those guys that didn't mind going on these more significant calls, and that was part of his complaint, that he was getting assigned nursing home calls. That wasn't enough action for him, and that was part of those complaints. It's interesting to note as well that the applicant Haley does not file for workers' compensation benefits, which normally you would do if you felt that your injuries were related to a duty call. He doesn't ask for PETA benefits, the Public Employee Disability Act, which normally an employee would do if they felt that they had a work-related injury. And that all went into the credibility of the applicant that the board considered here. I would point out in the reply brief, Appelli says that we raised new arguments that weren't part of the initial claim, which the board didn't do here. They all, in their decision in order, they said they felt that Haley was motivated by financial gain. And that's really what this amounts to, is it's if they're going to try to stick it to me and not let me come back to work, I'm going to seek the highest benefit I can and try to go back to the most significant call that I can recall back in January 2016 and try to relate it back. Unfortunately, none of the treatment records support that. And he's seen a significant number of times by a number of different treaters, as admitted to by the appellee. It's Dr. Naravana, who's one of he's seen him on 7 occasions, never mentions anything about this call in January 2016. He's seen by Dr. Sarah Guara at least on 2 occasions, never mentions the call in 2016. Sees Dr. Campion on 2 separate occasions, and he's being evaluated specifically for a psychological condition, and he doesn't mention the January 2016 call. It's only after he's not allowed to come back to work that he says he has PTSD because of this particular call. I just would like to point out as well, Dr. Harris, who the board relies on, did give a diagnosis. He said he suffered from chronic unhappiness/depression. While that may not be it's certainly not a PTSD diagnosis. Depression certainly is a mental condition, and that's the basis for why he finds him disabled, but he's very clear that it's not work-related. So to sum up my argument, Your Honor, and I'd be happy to answer any questions from the justices, the board had to look at the totality of the circumstances here. Not only did they have a medical opinion, where they had really 3 different medical opinions here. One said it was related to PTSD. One said that it was an aggravation with significant underlying things. And then you had Dr. Harris saying it wasn't related at all. But Dr. Harris was focused on the medical records, much like the pension board was, where there was 0 complaints of any condition. So where the board has to rely upon and weigh this medical evidence, it weighed it in favor of Dr. Harris. And we believe that it did so properly based on the totality of the medical evidence in combination with the credibility of the applicant here, where he had significant disciplinary issues and didn't make any complaints until he knew he wasn't going to be able to come back to work based on the fitness for duty. So based on all that, Your Honors, we'd ask that the pension board would ask that you affirm the denial of the line of duty in this matter. I'd be happy to answer any questions the justices may have.
I see none, so thank you, counsel. Then, Mr. Moran, on behalf of the appellant, you may make any rebuttal argument at this time.
Sure, I just have a couple, Your Honor. Certainly, I'm not going to take up the whole 5 minutes. We are not asking the court to reweigh the evidence. we are asking the court to re-examine the evidence. And as has been held in multiple decisions, the court has the ability to do that. This is not a rubber stamp, and you have the ability to re-examine this and determine if the board was correct or incorrect based on the manifest weight of the evidence. We continue to assert the problems in Harris's. The board says they didn't rely on Cassidy's opinion, but if you look on page 22 of the record, the board does say that they relied on Harris and Campion's opinions in determining this. And lastly, counsel interjects that because there was not a workers' compensation claim or a claim for PETA benefits, that had some indication that this was not an active duty. First, nowhere in the board's decision were those issues raised. We would ask that the court disregard those. Those are new arguments being presented. And second, whether somebody applies or doesn't apply for other benefits has really no bearing on whether somebody is or is not disabled from an active duty. And I thank the court for their time today, unless there's any questions.
Okay, thank you, counsel. The court will take this matter under advisement, issue a decision in due course, and we will now stand in recess.
Thank you, Your Honors.